Welcome, deep divers. Today, we're tackling something that sounds maybe a bit dry, but actually has huge real-world impact.
Definitely.
We're looking at international law,
Right.
specifically how countries interact legally within another country, our mission. To unpack South Africa's Foreign States Immunities Act of 1981.
That's right. Act 87 of 1981, to be precise.
And this isn't just for lawyers, is it? If you've ever wondered, why a foreign embassy seems untouchable or how a business dispute with a foreign government even gets handled,
Then this is for you. Absolutely.
we'll go through its purpose, the key rules, the background, and what it all means practically. So where do we start this exploration?
Well, I think the starting point has to be the core idea itself, state immunity. This whole act is designed to navigate that fundamental principle of international relations.
Okay.
It defines exactly when a foreign state can be sued in South African courts and when it can't be, when it's immune. It was assented to back in October 81, started November 81, and it's been updated since last check was recent, March 2025. So it's not some dusty old law, it's relevant.
Okay, let's unpack state immunity. It kind of sounds like a diplomatic get-out-of-jail-free card for countries, doesn't it?
It can seem that way sometimes, but the core principle is actually quite foundational in international law.
What is it, fundamentally?
It's often summed up in Latin, parem non habet imperium.
Which means?
Roughly, an equal has no authority over an equal. Basically, one sovereign country shouldn't be subject to the courts of another sovereign country without its consent.
Respect for sovereignty.
Exactly. And the Act's Purpose Clause says just that, to determine the extent of the immunity of foreign states and provide for matters connected therewith. What's key here is that this act really marked a shift for South Africa.
A shift how?
From what was traditionally seen as absolute immunity, where states were pretty much always immune, to a more modern approach called restrictive immunity.
Restrictive, meaning there are limits.
Precisely. It acknowledges that, states these days do all sorts of things, especially commercial stuff. Buying, selling, contracts.
Acting like a business almost.
Right. And the idea behind restrictive immunity is that when they act in that commercial capacity, they shouldn't automatically be shielded from the local laws governing those activities.
So it's about striking a balance. That makes sense.
Yeah.
And the act is clear on who counts as a foreign state, I believe. It's not just the country as a whole.
Absolutely. Section 1, the definitions, is crucial here. It says a foreign state includes its head of state acting officially, of course, its government, and any government department, like, say, the Ministry of Trade.
Okay.
But importantly, it specifically excludes a couple of things from that broad definition.
Such as?
First, what it calls separate entities. These are bodies that are distinct from the main government executive organs and critically capable of suing or being sued themselves.
Say the state-owned airline, maybe.
Exactly like that.
Yeah.
We'll get to their specific immunity rules later, but they aren't treated the same as the core government.
Got it. What else is excluded?
Also excluded are the constituent parts of a federal foreign state. So think of like a state within the USA or a province in Canada. They don't automatically get the same immunity as the federal government under this act.
Interesting distinction. And it clarifies republic includes territorial waters too, right? For geographic scope.
Yes, that's in there too. Important for maritime issues, for instance.
So the general rule, the default position is immunity. How strongly does the act actually state that?
Very strongly. Section 2 lays it out plain and simple. It says, and I'm paraphrasing slightly, a foreign state shall be immune from the jurisdiction of the courts of the Republic.
Shall be immune.
Except as provided in this act. So you start with immunity as the baseline, and then the rest of the act carves out the exceptions.
Okay.
And here's the powerful bit. Section 2, subsection 2. A court shall give effect to the immunity, even though the foreign state does not appear in the proceedings.
Wow. Okay, so the court has to uphold it proactively. The state doesn't even need to ask for it.
Exactly. It's treated as a fundamental principle the court must respect, not just a defense the state might raise.
That is a strong statement of immunity. But, as you said, it has limits. It doesn't cover criminal jurisdiction, for example.
Correct. The act specifies it doesn't subject a foreign state to the court's criminal jurisdiction. We're talking civil jurisdiction here.
Right. So now for the really interesting part, for many people, the exceptions. Where can a foreign state be brought before South African courts? Let's start with the most obvious way. What if the state just agrees?
That leads us straight to Section 3, which deals with waiver of immunity. How can a state give up this protection?
How can it?
Well, first, through an express waiver. They can explicitly say, we waive immunity for this dispute. This can happen after the dispute starts, or maybe
Beforehand, like in a contract.
yes, exactly, through a prior written agreement. But there's a really important catch here.
Yeah.
A clause in a contract just saying the agreement is to be governed by the law of the republic, that doesn't count as a waiver of immunity.
Ah, okay. That's just about which country's rules apply, not where you can be sued. Subtle, but crucial.
Very crucial. Then there's what's called a deemed waiver.
Deemed, meaning the law considers them to have waived it, even if they didn't say so explicitly.
Precisely. A state is deemed to have waived immunity if it actually starts legal proceedings itself in a South African court.
Stands to reason. If you use the courts, you accept their power.
Right. Or if it intervenes or takes any significant step in proceedings someone else started. Unless, of course, that step was purely to claim immunity or a certain interest in property where they believe they're immune.
So just showing up to argue we're immune doesn't count as waiving it.
Correct. And a waiver generally covers appeals and counterclaims related to the same issue. Interestingly, the head of a diplomatic mission, or someone who signed a contract for the state, is generally considered to have the authority to waive immunity for disputes related to those matters. Very practical. That makes sense if you engage you're generally in. Okay, so waiver is one path. But you mentioned earlier the big shift was because states act commercially. What about that?
Yes, Section 4, commercial transactions. This is really the heart of restrictive immunity.
So what's the rule here?
Basically, a foreign state is not immune in court proceedings that relate to a commercial transaction entered into by the foreign state, or if it relates to an obligation the state has under a contract which is supposed to be performed wholly or partly within South Africa.
So if they buy stuff here or agree to do something here under contract,
They generally can't hide behind immunity if a dispute arises from that transaction. There are exceptions to this exception, though, like if both parties are foreign states or if they agreed in writing to use another country's courts.
fair enough. But how does the Act define a commercial transaction? That seems potentially broad.
It does provide a definition in Section 4, subsection 3. It includes any contract for the supply of services or goods,
Okay, pretty standard.
any loan or other transaction for the provision of finance, and any guarantee or indemnity,
Financial dealings.
and then a catch-all. Any other transaction or activity of a commercial, industrial, financial, professional, or other similar character that a state engages in other than in the exercise of its sovereign authority.
Oh, that sovereign authority bit is key, isn't it?
Absolutely. It distinguishes between the state acting like a state and the state acting like a business. And very importantly, the definition explicitly says a commercial transaction does not include a contract of employment between a foreign state and an individual.
Right. So if a foreign state buys office supplies for its embassy here or takes out a loan locally, it can't just claim immunity if there's a payment problem. That's huge for local businesses.
Yeah, exactly.
But since employment contracts are carved out of that commercial definition, how are they handled? Say, for a South African working at an embassy.
Good question. That's covered specifically in Section 5, contracts of employment.
And what does that say? Is the state immune or not?
It's not immune in employment contract disputes, provided certain conditions are met.
Okay, what are they?
1, the contract was made in South Africa, or the work was supposed to be done wholly or partly here.
Makes sense.
2, the individual employee was a South African citizen or ordinarily resident here when the contract was made.
Protecting locals.
And 3, the employee is not a citizen of that foreign state when the court proceedings start.
So it doesn't apply if, say, a French embassy employs a French citizen here.
Correct. But even if those conditions are met, there are still exclusions. The state remains immune if the parties agreed in writing to use foreign courts, or, and this is vital, if the job involves diplomatic or consular staff.
Like the ambassador or their admin staff.
Yes, head of mission, administrative, technical, service staff. The core diplomatic functions are protected. You can't have local courts interfering with the internal staffing of an embassy.
That's a very specific layered approach. Protects local non-citizen employees in most cases, but safeguards the diplomatic corps. Okay, what about more direct harm? Like personal injuries or damage to property caused by a foreign state?
That's Section 6, personal injuries and damage to property.
And the rule?
A foreign state is not immune in proceedings related to the death or injury of any person or damage to or loss of tangible property if it was caused by an act or omission in the Republic.
So that example of an official embassy car causing an accident here.
Precisely. In that case, immunity generally wouldn't apply to a resulting lawsuit for damages caused in South Africa.
Pretty clear cut. What about disputes over actual physical assets? Buildings, land owned by a foreign state here.
Section 7 deals with ownership, possession, and use of property.
Is there immunity?
Generally, no. A foreign state is not immune in proceedings about its interest in or its possession or use of immovable property in the Republic, like land or buildings, or any obligation arising from that interest or use. It also covers property they might get through inheritance or as ownerless goods, bona vacantia.
But surely there's an exception for the embassy itself.
Absolutely. Section 7, subsection 2, carves out a crucial exception. This rule does not apply to property used for a diplomatic mission or a consular post.
So if a foreign state buys a commercial building as an investment, they can be sued over it. But if it's their actual embassy or consulate building,
Immunity generally holds for the embassy or consulate premises, protects their operational space.
makes sense. We're seeing a pattern. Act commercially, cause harm locally, own regular property locally, immunity likely falls away. What about things like patents or trademarks, intellectual property?
Section 8 covers patents, trademarks, etc. Same principle, really.
No immunity if.
If the proceedings relate to intellectual property rights, patents, trademarks, designs, plant breeders' rights that belong to the state and are registered or protected here or that they've applied for here, or if the state is alleged to have infringed someone else's IP rights or copyright within the Republic, or if it's about the right to use a trade name here.
So if they're engaging commercially, they also have to play by the IP rules.
Essentially, yes.
Are there other specific scenarios like this where immunity is lifted?
A few more key ones. Section 9 deals with membership of associations and other bodies.
What's that about?
If a foreign state joins some kind of association, body, corporate, or partnership here in South Africa,
Like a local industry group?
could be, yes, as long as that body also has members who aren't foreign states,
Sure.
and it's either incorporated or controlled here or has its main base here,
Then
then the foreign state is not immune in disputes about its membership that arise between it and the association or the other members. Again, unless there's a written agreement or rule saying disputes go to a foreign court.
protects the integrity of local organizations, you could say. And what if a state agrees to arbitration? Does that affect immunity?
Yes. Section 10 on arbitration is very clear. If a foreign state has agreed in writing to submit a dispute to arbitration,
Like in a contract clause?
exactly, then it is not immune from the jurisdiction of South African courts in any proceedings that relate to that arbitration,
Such as?
such as enforcing the arbitration award or challenging it, for example. By agreeing to arbitrate, they implicitly accept the court's role in supervising or enforcing that arbitration.
Unless, again, they agree the arbitration itself falls under foreign court supervision, or if both parties to the arbitration are states.
Correct. Those are the standard exceptions.
Okay, that seems logical. What about a really specialized area like shipping? Admiralty law, ships, cargo. That must be complex with state-owned vessels.
It is, and Section 11, Admiralty Proceedings, deals with it quite carefully.
How does it work?
It distinguishes based on the purpose the ship or cargo is being used for. A foreign state is not immune in certain maritime actions, whether in rem against the ship itself or in personam against the state, if, at the time the legal issue arose, the ship belonging to the state was in use or intended for use for commercial purposes.
Ah, the commercial test again.
Yes. Same applies to cargo on a ship. If both the cargo belonging to the state and the ship carrying it were being used or intended to be used for commercial purposes when the issue arose, then no immunity for related legal actions.
So a warship on patrol is immune?
Generally, yes. That's sovereign use.
But a state-owned tanker carrying oil for sale is not.
Generally not for disputes related to that commercial voyage or cargo. Belonging to is defined broadly too, includes ships or cargo in the state's possession or control, or in which it just claims an interest. It clearly targets state commercial shipping.
That makes a lot of practical sense for global trade.
Yep.
Okay, one last exception area. What about taxes? Do foreign states have to pay local taxes?
Section 12, Taxes and Duties, clarifies this. A foreign state is not immune from court proceedings about its liability for things like sales tax or any customs or excise duty, or for rates in respective premises used by it for commercial purposes.
There it is again, commercial purposes.
Exactly. So if they own a building used for commercial activities, they're generally liable for property rates on it. Diplomatic premises, of course, usually enjoy tax exemptions under separate international agreements, like the Vienna Conventions. This act is targeting their commercial side.
Got it. So we've established when you might be able to sue a foreign state, but the next big question is how. You can't just, I imagine, knock on the embassy door with a summons.
No, definitely not. Section 13, Service of Process and Default Judgments, sets out very specific procedures precisely because you're dealing with a sovereign entity.
It could be done.
Any legal document, like a summons, must be served by being transmitted through the Department of Foreign Affairs and Information of the Republic. That's DIRCO now, of course.
Right, the Department of International Relations and Cooperation.
Yes, transmitted through them
Yeah.
to the Ministry of Foreign Affairs of the foreign state concerned.
So government-to-government channel.
Essentially, yes, and service is only considered effective when that foreign ministry actually receives the document.
Okay, and then what? Is there a standard time to respond?
Yes, and it's generous. The time limit for the foreign state to respond, like filing a notice of intention to defend, only starts running 2 months after their foreign ministry receives the document.
2 months, that's much longer than usual.
It acknowledges the time needed for international communication, translation, getting instructions, etc., and you can't get a default judgment against them unless you can prove you followed this service procedure and that the 2 months have passed.
And even if you get a default judgment.
A copy of that also has to be transmitted the same way, and they get another 2 months from receipt to apply to have it set aside.
Wow. Very protected procedure. Can states agree to faster methods?
Yes, the Act allows for states to agree in writing to other methods of service, and these strict rules don't apply to things like counterclaims or those in rem actions against ships we mentioned earlier.
That's an incredibly important practical detail for anyone considering this. But okay, let's say you navigate all that. You follow the process. You argue your case based on an exception. You win a judgment. Can you actually enforce it? Can you seize the foreign state's assets here? That feels like the ultimate sovereignty clash.
It is a very sensitive area, and this brings us to Section 14, Other Procedural Privileges, which deals with enforcement. And the starting point is protection.
Protection for the state's assets.
Yes. Generally, the Act says you cannot get relief against a foreign state through an interdict or order for specific performance or for the recovery of any movable or immovable property.
So no court orders telling them to hand over property or do something specific, usually.
Correct. And crucially, the property of a foreign state shall not be subject to any process for attachment.
Attachment.
Seizing it, whether that's to start a case or, more importantly, to enforce a judgment or arbitration award you've already won, or for attachment and sale in those in remship actions. This immunity from execution, as it's called, is quite strong. It was even reinforced by an amendment in 1985.
So winning a case is one thing, getting paid is another. Are there any exceptions to this enforcement immunity?
Yes, there are 2 main ones.
Okay.
First, the foreign state can give its written consent. This could be in a prior agreement, maybe limited to certain assets. But, and this is critical just because they waived jurisdictional immunity, agreed to be sued, that does not automatically mean they've consented to having their property seized for enforcement.
So waiver of immunity to be sued and consent to have assets seized are 2 totally separate things.
Exactly. You generally need explicit, separate consent for enforcement against their property.
That's a huge hurdle. What's the second exception?
The second exception links back to our recurring theme, commercial purposes. The prohibition on attaching property does not apply to property, which is for the time being in use or intended for use for commercial purposes.
So if you won your case against the state over that commercial supply contract,
You might be able to attach assets they hold here for commercial purposes, like funds in a regular commercial bank account used for business dealings, or maybe that investment property they own.
but not the embassy bank account or the embassy building itself.
Definitely not. Those are considered sovereign or diplomatic assets, not commercial, and remain protected from seizure under this act.
It's a very fine line, but a crucial one. Allowing some recourse against commercial assets while strictly protecting sovereign and diplomatic property. Okay, we mentioned separate entities right at the start, those state-owned companies.
Yeah.
Do they get the same strong immunity from having their assets seized?
Not necessarily. Section 15, immunity of separate entities, addresses them specifically. Remember, A separate entity is only immune from being sued in the first place if the case is about something it did in the exercise of sovereign authority and if the state itself would have been immune.
Right. So usually not immune if acting commercially.
Exactly. And following that logic, if they aren't immune from being sued for their commercial actions, their commercial property generally isn't immune from enforcement either, under Section 14's exception.
So the property of a state-owned airline used for its commercial flights could potentially be attached.
In principle, yes, if it's genuinely commercial property related to the judgment. However, Section 15 adds a special protection for one type of entity,
Which is
central banks. It explicitly states that property belonging to a foreign state's central bank or other monetary authority is not considered in use or intended for use for commercial purposes under those enforcement rules in Section 14.
so the core financial reserves and assets of a foreign state held by its central bank get extra strong protection from seizure, even if other state entities' commercial assets might be vulnerable.
Precisely. It protects the core financial sovereignty of the foreign state.
That's a really critical distinction for anyone involved in international finance or disputes with state entities. Now, what if the rules in this act aren't quite aligned with what another country offers South Africa in return? Or maybe conflict with an international treaty? Is the act set in stone, or can it adapt?
It can adapt. Section 16, Restriction and Extension of Immunities and Privileges, provides a mechanism for this.
How does that work?
It gives the state president the power to adjust the level of immunity South Africa grants to a specific foreign state.
Adjusted how?
If the president determines that the immunities and privileges South Africa gives that state under this act either, 1, exceed or are less than those accorded by the law of that foreign state in relation to the republic.
So, based on reciprocity, how they treat us.
Exactly. Or 2, if our rules give less than those required by any treaty, convention, or other international agreement that both South Africa and that foreign state are party to.
To meet treaty obligations.
Right. In either case, the president may, by proclamation in the Gazette Restrict, or, as the case may be, extend those immunities and privileges for that specific state to bring them into line.
So it's not a one-size-fits-all. It can be tailored based on specific bilateral relationships or international agreements. That's quite dynamic.
It allows for flexibility in foreign relations, yes.
One last procedural point.
Yeah.
In these cases, how does a court even establish basic facts like, is this entity actually a state? Or who is the head of government right now? That could get complicated.
Section 17, Evidence by Certificate, provides a neat solution.
Which is?
A certificate issued by or on behalf of the Minister of Foreign Affairs and Information. Again, now DRCO is considered conclusive evidence on several key factual questions.
Like what?
Like whether a foreign country is a state for the purposes of this act, or whether a territory is part of a federal state, or who the current head of state or government is, or even confirming when those legal documents were officially served or received under Section 13.
So the court doesn't have to conduct its own investigation into these potentially complex international facts. It can rely on a certificate from our own foreign ministry.
Correct. It streamlines the legal process by providing an authoritative answer on those specific points.
And that, I think, brings us pretty much to the end of our deep dive into the Foreign States Immunities Act, 1981. We've covered a lot of ground.
We certainly have.
From its core purpose, balancing sovereignty with accountability, through all those exceptions for commercial deals, employment, property, injuries, right down to the nitty-gritty of serving papers and trying to enforce a judgment.
It's a complex but logical framework, really.
So thinking about our listeners, future lawyers, business people, or just curious citizens, what's the big takeaway message from all this?
I think if you connect it all, the Act essentially paints a picture of foreign states operating with, let's say, 2 hats within South Africa.
Yeah, hats.
Yeah. When they wear their sovereign hat, acting purely as a government, performing public functions, they generally get the strong protection of immunity, that respect for par in parum.
Okay.
But when they put on their commercial hat, stepping into the marketplace, entering contracts, buying goods, running state-owned businesses, that shield of immunity becomes much, much weaker under this act.
They become more accountable, like other players in the market.
Exactly. This move from absolute to restrictive immunity acknowledges that modern reality. States act commercially, and there needs to be a fair mechanism for resolving disputes arising from that, while still carefully protecting their core diplomatic and sovereign functions.
That's a brilliant summary. The 2 hats metaphor really clarifies it. It shows how a specific law like this addresses those broad international principles in a very practical way. So To leave our listeners with something to chew on, what's a final, perhaps provocative thought stemming from this act?
Well, considering that Section 16 allows the president to adjust immunities based on reciprocity or treaties, it makes you wonder, doesn't it?
Wonder what?
In today's world, which is, increasingly interconnected, but also sometimes quite volatile, how might changing global politics or maybe new forms of international interaction we haven't even fully grasped yet continue to push and reshape these boundaries?
You mean what counts as sovereign versus commercial might change? Or how reciprocity is judged?
Perhaps. Think about things like state-sponsored cyber activities or complex public-private partnerships involving states, or even actions in space eventually. How will the principles embedded in acts like this one be interpreted and applied to keep that balance between justice and sovereignty fair and relevant in the future?
That is a fascinating question to ponder. Where do those lines get drawn as the world keeps changing? Food for thought indeed. Thank you so much for guiding us through this complex legal landscape.
My pleasure. It's an important piece of law.
And thank you all for joining us on this deep dive. Until next time, keep digging, keep learning, and stay well informed.